आर्टिकल 62(1) के तहत ना अहली की मुद्दत ता हयात या फिर 5 साल। बड़े केस की पहली समाअत का ये मामला समा आपको दिखा रहा है।
42 of the specific relief act, which talks about declaration of a legal character. Now, this cannot be that kind of a declaration because, as your lordships have repeatedly observed, a negative declaration is impossible to obtain. Then your lordship,
sometimes permissible negative declaration is permissible sometimes in some events that can be granted by the court.
There has been some revisitation or some revisitation of Alvi Sons, but otherwise that remains good law. Then if your lordship looks at 199, that also is talking of declarations being made by this honorable court, but that's in a completely different context.
That is only.
So then what do you make out of this declaration for a court of law?
My lord, I would say that the term is not used specifically in the section 42 sense of the term.
Maybe it's a constitutional declaration.
It's a constitutional declaration, and that the declaration which the constitution is envisaging is there has been a conviction already under 63(1)(h. And then there is this gateway. He cannot file his papers before the returning officer because at that time the returning officer may refuse to accept them. But the anomaly which arises when your lordship looks at 63(1)(h in particular and G and H both, actually, when your lordship looks at it, for instance at H, he has been on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years unless a period of 5 years has elapsed since his release. So even a conviction which is followed by a sentence of 1 year 11 months does not lead to disqualification even of 1 day.
Enough. So that's understood.
So therefore the connection which Samiullah Baloch makes between a person being an ex-convict suffering all his life the stigma that he's a convict is really not what 63(1)(h is all about. 63(1)(h is all about sentencing. If the person has been convicted and sentenced till the rising of the court, he's not disqualified at all.
No, but there is a difference, you see, the opening paragraph of section 62 and 63.
My lord,
they need to be read and harmonized. A person shall not be qualified to be elected or chosen. And if you will read 63, a person shall be disqualified from being elected or chosen. So वो जो उसमें चीजें लिखी हैं वो आफ्टर कन्विक्शन है कि अगर कोई कन्विक्ट हो गया है उसकी सजा खत्म हो गई है तो इस इतने पीरियड के बाद वो इलेक्शन लड़ सकता है. To be elected and from being elected. This is the
correct. But if your lordship may graciously be pleased to look at clause 2 of 62, these words are used very loosely. The disqualification specified in paragraph D and E doesn't talk about qualifications. Article 62.
But both are different situations.
No, my lord, Article 62, Clause 2 is talking of disqualifications under 62. It's not talking of qualifications. So this is very loose language which has been used.
Practically interchangeable.
Interchangeable language. Because
one question which I have. DE does not have the wording there being no declaration to the contrary by a court of law.
My lord, yes.
When does D, E and G kick in?
How can they ever kick in actually in any court of law? They cannot kick in.
Or they're meaningless words?
My lord,
it's just guidelines.
Are exhortatory perhaps for the guidance of the electorate that watch out for candidates.
So like first of all, you are saying that they are of no, there are no consequences which follow with D, E and F. D, E and G.
They will, my lord, D, E.
But ideally, the same wording should have been used, there being no declaration to the contrary by a court of law in D, in E and in G.
My lord,
these wordings are only found mentioned in F.
My lord, these were added in F under the 18th amendment. These words were originally not there, and the reason for adding it appears to be, as the Attorney General identified, that under F, returning officers had started disqualifying people by saying, "Aap chautha kalma zara suna dijiye." आप चौथा कलमा जरा सुना दीजिए, इस तरह की चीजें.
They can still do that in E.
They can. They very much
That's
can.
the problem, you see. What we don't understand is the D, E, G are there, and what do we? They're not executable as such. How could we? So, I mean, I myself read them as for the gatekeepers, as the voters, and maybe they keep that in mind and not vote because it's a subjective decision.
My lord, yes.
But cannot be enforced in a court of law.
My lord, that is what in the case of Ishaq Khan Khakwani, one of the learned judges, as my lord Mr. Justice Faiz Isa identified in Sheikh Rashid's case, took the view that no disqualification can really take place over here. These are very open-ended words. And your lordship points it out in your dissenting opinion in Sheikh Rashid's case, where your lordship identifies the 7 questions which are to be dealt with by the court, because that's...
But Mr. Makhdoom, the problem is that I am facing is you can't attribute redundancy to the Constitution.
My lord, yes.
Or to any law for that matter. And then secondly, you can't read into the Constitution. So the time frame, suppose if one were to say that this F applies for that election, that particular election which the nomination papers are rejected, and it ends. Now that's not written. So how, I mean, that's the worry that I have. How do we read in a time frame into it? Either we read them with 63 and create a larger timeline concept. How does it work? Or go on the validation point.
And if I may just add what my learned brother has just said, what I've understood from your submission is what you are saying, Sameullah Baloch does not accord with the Constitution.
That's the submission.
That's your argument. Can we not say that Sameullah Baloch for its time was good, valid judgment? However, since the lacuna has now been provided by Parliament, and they've given a 5-year time limit, both can be reconciled. That was good then, and now 5 years is. If your 5 years have expired, would you agree with that, or you would not agree with that?
No, I would absolutely agree with that, my lord. My submission is that Sameullah Baloch was enacted, was decided at a time when we didn't have this newly amended law. At that time, the law did not, and there was no timeline set. The Sameullah Baloch case was decided in a particular manner. The legislature has now filled that gap. In Sameullah Baloch, it was observed that there is a declaration. Until such time that the declaration stands, then the person would remain disqualified or will not be qualified. Now the legislation says that the period of such a declaration will not go beyond 5 years.
5 years. Okay, now I will ask you the supplementary question, and I knew you would come here. Thank you. Now can I put it to you that Section 232(2) is unconstitutional? Can I put this to you or not?
My lord, that is a very valid question. Of course, your lordship can put any question.
Yes.
My lord, because one view can be, which is probably in my opinion, definitely the correct view, that where this honorable court has interpreted a provision of the Constitution and made a declaration about a provision of the Constitution, then on the doctrine of legislative repeal, that constitutional interpretation can only be undone by an amendment to the Constitution.
And that brings us to the question that how could the Constitution be controlled by a sub-constitutional legislation? The Constitution is talking about a declaration, gives no time frame. Could we, through an act of Parliament, start adding things to the Constitution? We can't do that.
My lord, I would say that the declaration made by the Parliament is in consonance with Article 63(1)(h) of the Constitution, which provides a time frame for the kind of offences which will fall under F.
Because that involves conviction, that's a criminal case. But if you look at 63P, 1P or whatever it is, the P, the last one.
Yes, madam.
The Constitution itself allows that through an act of Parliament you can regulate this provision. And wherever it's so required, it's given.
So, just taking it a little more, suppose, let's imagine Sameullah Baloch was not decided. And we are deciding it today.
My lord.
Just for the sake of, to take the argument a bit forward, and let's assume everyone agrees with me And we say, since 62(1)(f) does not provide a time limitation for disqualification, therefore let us be guided by other provisions of the Constitution, including 63(1)(h) and (g), where it provides for treason 5-year disqualification. So let us let this disqualification be for 5 years. Is it sound reasoning or not?
My lord, it is, because your lordship is then virtually interpreting the two provisions together. When your lordship interprets...
So at the end of the day, it depends on what is in my mind. Are you understanding?
Yes, my lord.
Is the Constitution so malleable that I can do whatever I want to with it?
My lord, if 63(1)(h) was not there, let us assume there was only 62(1)(f), and if the 18th Amendment had not added the words